Hello guys, my name is Gauri Bandre and I'm first year LB student of Delhi University. My topic for today's discussion is divorce. So in today's topic we are going to see what is divorce and what are the various alternative dispute resolution rather than divorce, and some basic questions which are asked during divorce. What will be the common grounds and additional grounds for divorce for women, etc. Previously, we used to believe a marriage to be a sacramental relation, or something which there is no breakdown of marriage. There is no concept of breakdown of marriage. Marriage is irrevocable. So once when if you are married to a person, you are going to be married to that same person for ages and ages, unification of soul, etc. We used to believe in that concepts, but as the time passed, we challenged this traditional means and customs, and then the basic few grounds of dissolution of marriage was introduced. That being said, let us now understand the various grounds for divorce one by one, briefly, and few additional grounds which are available for women. In the case of adultery, means mere attempt of adultery cannot be the basis of adultery. Now, here we need to understand that if you doubt that your spouse is in a sexual relation, a consensual sexual relation with somebody other than you, then that won't be the basis of divorce, because only mere attempt or assumption is not adultery, right? If you're doubting someone, it can't be considered under adultery. You need to provide at least circumstantial evidence, not if not fixed evidence. If you don't have any fixed evidence, then you can provide circumstantial evidence to the court of law, and then it will depend on the judge to decide whether this is the basis of divorce or not. Second being said is cruelty. Now cruelty can be differentiated between physical and mental. So in physical, you have a proof, you have evidence that okay, somebody or the other spouse has behaved in a certain way. Either they have beaten you up, or they have insulted you in front of the whole public, or has tortured you in some or the other way. But whereas mental state is concerned, in mental there should be circumstantial evidence. Again, you don't need to only one thing can't result to divorce, right? There will be n number of reasons why you have jumped into this conclusion. So you need to provide all those examples, or it will again depend on the circumstances and the understanding of the judge, how reasonable you are trying to justify the reasons, etc. Now for an example, in example, if I am married to B and B is torturing me not only once, like he is doing certain acts. If I'm leaving for work, then he is hiding my stuff, or he is beating my child when he is sick, or in a very vulnerable state. Third reason can be if he is insulting me in front of my in-laws or my family. Fourth will be if he is torturing my brother or sister, etc. So these can be n number of reasons which may result to mental torture, and hence can be the basis for divorce. Third will be desertion. Again, desertion are also divided into two: actual desertion and constructive desertion. So in actual desertion, your spouse, like a person is actually deserting the other person and leaving that area, leaving that matrimonial home, or maybe that person without giving any reasonable reason to that person. But in constructive, on the other hand, they both are living under same roof, but still they are not in the talking terms, or maybe that person is ignoring or not treating or not fulfilling the responsibilities which the other spouse should fill during a matrimonial marital relationship. So this is how we differentiate between actual desertion and constructive desertion. In actual desertion, minimum of 2 years period should be fulfilled. Now if let's assume if my husband has left me, and like the 2 years are going to get completed within maybe 2 months, say next 2 months, but he returns before that and he accepts to be with me in a normal relationship henceforth, then you can't give the basis for uh, desertion in this case, because he has returned and uh, he has consented to resume the marriage again. So this can't be the basis. And next will be conversion. So in conversion also, conversion is basically getting converted to some different religion than Hindu. Now if say X is getting converted from Hindu to Buddhism or Sikhism, then it won't be considered under conversion, because the Sikhism and Buddhism are a part of Hindu religion, so it won't be the basis of divorce. If that same person is getting converted into let's say Muslim religion or Christian religion, then it will be considered into conversion, and the person who has converted himself cannot apply on this basis for divorce. Next is mental disorder. Mental disorder is if that person is unstable or getting regular fits of act, then it will be considered under mental disorder. Next is incurable form of leprosy. So if somebody is facing from incurable leprosy, then this can be the basis of divorce. Seventh is venereal disease or communicable disease. Eighth is renunciation. So renunciation are again segregated into two parts. One is tyag and second is sannyas. Tyag won't be considered into this, because tyag will be a part of desertion and not renunciation. In renunciation, we will consider sannyas as a part. So presumption is death basically means that missing of person. If somebody is say leaving you for a certain period of time, maybe 6 months, and then returning back, then again you are continuing your relation, and again then that person is leaving. So in this case you can't apply for renunciation. Presumption of death, it should be minimum of 7 years for the basis of divorce. Next is there are additional 4 grounds for a wife to get divorced. One being bigamy. That person should marry some other woman when he is in a matrimonial relation with his ex-wife or present wife. In that case, not the second married woman, but the first married woman. Matlab, the one who is at first got married to that person can only apply for bigamy. Second is rape, sodomy, or bestiality. Rape can also be basis of divorce in this case. Third is repudiation of marriage, means on the option of puberty. If that girl has not completed 15 years of age, then she can apply for divorce on this basis. Non-cohabitation, that if a woman has applied for decree for resumption of marriage to the court, still that person has not resumed with his matrimonial responsibilities, uh, or is not providing maintenance to that woman, then this can be one of the basis for applying for divorce. Understand what are the different solutions rather than divorce which one can apply for. Now in judicial separation, your marriage doesn't get dissolved. You are married to that same person, but you are judicially separated. You have independent life and nobody is liable to fulfill the responsibilities of each other. This can be more preferred solution and more sensible if you want to be in a healthy relation with each other. Second can be mutual consent. Now in mutual consent you both are agreeing onto the same terms of dissolution of marriage. There is no hardship while getting marriage, or you are not ending the relation in a bad terms. For mutual divorce, the minimum waiting period is 6 months. 6 month period is mandatory because it gives you time for reconciliation and hence believed to be mandatory. Second is unilateral withdrawal. Now, what if in case, let's say in this 6 months period, you both at first instance agreed to give mutually divorce to each other, but after a certain period, let's say 4 months, one of the spouse withdraw from this agreement, then the whole process will collapse, because mutual consent is basically formed on the basis that you both are agreeing on the same terms, and there is same common grounds for divorce. But if one of them is not agreeing to the same, then it will be withdrawn. Next, the very common questions which people tend to ask while getting divorced is, when can a divorcee get remarried? So a divorcee can get remarried as soon as the divorcee completes the whole process of dissolution of marriage with the ex person, and if there is no appeal pending in front of the court, and even if there is an appeal pending, it has been dismissed or expired in front of the court of law. Second, very common question is, when can you apply for divorce? Then the minimum 1 year of marriage should be completed, after which you can apply for divorce. Third is, when can you remarry the same person whom you have divorced? Then yes, you can remarry the same person under Hindu Marriage Act. There is no objection for getting remarried to the same person. Uh, Only while applying, the status would change. Now, first you were not married and now you are divorcee. That is only going to change and nothing else. So these were the very common questions which people tend to ask, and the common grounds for getting divorced under Hindu Marriage Act. Thank you.